Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
State of Michigan versus Tyler Stafford. Two files here today, 2220531 and 22F21943. I believe he's been arraigned on both of these files and has had the public defender's office appointed. So you may proceed when you're ready, Ms. Vergils.
Assistant Public Defender Chelsea Vergils with and on behalf of Tyler Stafford. We would ask to address bond when the court is ready.
Go ahead, Mr. Publiski.
Your Honor, Ryan Publiski for the people. I believe these are just two bench warrant cases. The possession at $10,000 and the OWI at $20,000. We're just going to ask that you maintain those cash surety bonds.
Thank you. I think Judge Simpson actually may have denied bond on one of these. I'll dig through that while we hear from his bond was revoked. Oh, here it is. Mr. Stafford's bond was revoked. He was ordered to turn himself into the Washtenaw County Jail back in February of 2023. He did not do that and did not appear for his next court date either. And then there was a no bond, a bond denied bench warrant issued. Yes, there's been some treatment and some other things going on, but I think the issue here is that he was ordered to go to jail and didn't. And so that order is still out there in effect because it hasn't been changed. Mr. Stafford filed a bench warrant recall request. It looked like maybe his lawyers helped him. And Judge Simpson denied that request back in July of 2023 because he still was needed to go to jail. So I think that's where we are, but you can say whatever you'd like to, Ms. Vergils.
Thank you, Your Honor. Just to put a few things on the record, my client has struggled extensively with substance abuse issues, but is happy to report a sobriety date of April 19th, 2023. He did do treatment and then moved to transitional housing where he still lives. The address given is his family members who make sure that he does get his mail. He's also been working full time and going to WCC for social work. We're asking you to consider not denying bond in these cases. We are not asking for a personal bond. From what I understand, he has a warrant, and to avoid the risk of him being picked up and get some time served on these cases, we're asking you to set a lower cash bond. Thank you.
Okay, so Mr. Stafford, the big issue here, of course, is that you were ordered to go to jail and you didn't.
Right.
So that order still stands. I have no idea what Judge Simpson wanted other than for you to turn yourself in. I didn't know if he wanted you to serve a particular number of days or if he wanted you to get some sort of a alcohol tether or what it was that he was looking for. That's not in the file. All that's in here is that you needed to turn yourself in. So it's not appropriate for me to do anything when a judge has ordered someone to turn themselves into the jail. I shouldn't have anything to do with that because that's an order from the judge that jail time is expected for some reason. So it's not an unreasonable request for there to be a financial component to get credit for time served, but Judge Simpson wanted you to be in jail and he wasn't expecting that there would be a bond. So I'm not going to set one. So on the 22F21943, your bond is denied per Judge Simpson's instructions. And your court date for that one will be on June 20th at 9 a.m. in person with Judge Simpson. On the misdemeanor, when you didn't appear for that case, it looks like Judge Barr issued a $20,000 cash and that there was some sort of a bond violation at that time. Looks like maybe not obtaining a sober link as ordered by the judge and testing positive for other drugs. So I'm going to schedule the bond violation hearing and the pretrial on that case together. Those will be on June 12th at 11 a.m. with Judge Barr, and I'm going to keep the bond that Judge Barr set, which was the $20,000 cash, primarily because you're going to be in front of Judge Barr well before you are in front of Judge Simpson. Do you have any questions?
No.
Okay, you're all set then. Thank you.
Thank you.
Several days later.
State of Michigan versus Smith 24F55133. I have received a petition requesting a court-appointed lawyer. I will sign that. Mr. Smith, could you state your name for the record, please?
Jovan Smith.
Thank you. Go ahead when you're ready, Ms. Vergils.
Assistant Public Defender Chelsea Vergils with and on behalf of Jovan Smith, we would request a formal reading of the complaint, stand mute, and ask to address bond.
All right, one moment. The complaint in this matter states that on or about June 9th, 2024, at Jackson Road and Gray Lake Avenue in the city of Ann Arbor, Washtenaw County, Michigan, defendant is accused in count 1 of operating a motor vehicle while intoxicated, causing death. The decedent is a person named Terrell Downgantha. I'm not sure I'm saying that right. Maybe it's Duan Chantha. The maximum penalty for that is 15 years in prison and a fine of up to $10,000. Count 2 is a charge of operating while intoxicated, causing serious injury. The alleged victim in that count is Devontae Turner. That's a felony with a maximum of 5 years and or $5,000. Go ahead, Ms. Robbins.
Thank you, Your Honor. The bond form in this case is pretty detailed, and of YouTube, I don't feel the need to put too many details on the record.
I took the testimony on this.
Great. But in the bond form, we are asking for $50,000 surety, alcohol and drug testing if he is released, an alcohol scram tether, no driving, and other standard felony conditions.
All right. I guess I'm not totally sure what the basis for that is, other than the events as they allegedly occurred. I don't see that he has any previous criminal history.
No, merely based on the incident, the admissions made at the scene, blood alcohol level. We're still waiting on lab results, I believe. But based on what's in the police report, and it's pretty detailed in the bond form, but that's the basis for our request.
Thank you. Go ahead, Ms. Vergils.
My client, Mr. Smith, is a student at a college in Ohio for physical therapy and plays football. As you may have seen, and from what I can tell, my client does not have any criminal history whatsoever in the state of Michigan. He has lived in Michigan his entire life. He's just going to college in Ohio, so he does live in a dorm there, but the address given is family members who ensures that he receives his mail. We're asking for him to be released on a personal bond with a scram tether. My client is not a danger to the community. The lack of criminal history and his stable lifestyle, academic lifestyle shows that. He promises to follow conditions and will not be driving. We're asking for a personal bond, and we're asking you to consider allowing him to continue going to school in Ohio. I didn't want to state the name of the exact college on the record, but he does want to continue his academic career. So we're asking you to consider release on a personal bond.
Is he taking classes over the summer?
Mr. Smith, what's your schedule like this summer?
I don't think I'm gonna take classes, but I still have to see. I have to talk to my football coach about it.
Okay, so you need to go to Ohio for, not for classes, but for football practice?
Yes, right now it's all season, but I'm home until it's time to go back, which is in July.
Okay, so you don't need to go right now, you need to go
No.
in July.
Yeah, if I did classes over the summer, it'll be online.
Okay. All right, so anything else, Ms. Vergils?
No, thank you, Your Honor.
So, Mr. Smith, when setting bond, what the magistrate or the judicial officer, so today that's me, what I'm supposed to be considering is two things. One, is the defendant a flight risk? And two, is the defendant a danger to the community? So, obviously, you were involved in a tragic and traumatic situation, and the results of that were serious and led to these criminal charges. The question then is whether that incident indicates an ongoing danger to the community or a flight risk. I don't have any reason to think that you're a flight risk. There's no information that I've been given that indicates that you wouldn't cooperate with court orders or appear for your court dates going forward. As far as danger to the community, everybody who is operating a motor vehicle under the influence of anything, whether that's a little bit or a lot, presents a danger, period. Usually that doesn't result in anything, frankly, but sometimes it does. And so I guess the question is whether the results of this incident indicate that you are dangerous, more dangerous than all of the other people that I see that are operating motor vehicles in situations like this. I don't think that the results of this crash change the dangerous equation, but I am going to set some kind of a bond because, as I said, there still is a danger. So I'm setting your bond at $20,000 cash or surety, no 10%. The conditions that I'm issuing are fairly typical for a case like yours. So while you are on bond, you are not to use alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, weapons, or ammunition. No drinking and driving. Any amount of alcohol in your body and driving violates the bond, even if your blood alcohol level is legal. So zero tolerance on that. Do not leave the state of Michigan without permission of the court. For now, I'm going to keep that. It doesn't sound like you need to go to Ohio right now. And when you are ready to go, your lawyers can talk to the judge about getting permission to go if that's something that you need to do later. But your court date's going to be soon, and I don't think we need to include that at this time. I'm going to order a couple of restrictions on, or a couple of testing requirements, I should say. So I'm going to order both testing and an alcohol tether. I'm ordering a Scram alcohol tether, which is a device that monitors your blood alcohol level continuously, so that needs to be set up with you prior to your release from custody. And then for the testing, I'm ordering random drug and alcohol testing one time. I'm only ordering it one time a week. That may change as your case progresses. Actually, I'm going to order it 2 times a month since we're doing the alcohol monitoring, and then just a test for other kinds of drugs. And that will begin within 24 hours of your release from custody. So when you get closer to that time, you'll get some more information about what you need to do. Your court date will be on June 20th. That's going to be at 9 a.m. in person with Judge Simpson. Okay, anything else on this matter?
No, thank you.
Okay. All right, you're all set, Mr. Smith. You can stand up and walk to the door. Thank you.
Thank you.